There are what I like to call three magic moments when you want to send a dispute letter to a debt collector. And most people don't realize this, but there's a 30-day window where a dispute letter to a debt collector becomes almost unstoppable. If you miss it, you may lose leverage, and if you know it, you can own the case. Magic moment number one, within 30 days of their first notice to you. So when a debt collector sends you that first letter, the one with all the legal warnings, you have exactly 30 days to send a written dispute. Here's what happens if you do. They must stop all collection activity. They can't call, they can't text, they can't report it on your credit report. They can only contact you once they validate the debt. And if they break this rule, you can go after them under the FDCPA. That's not a suggestion, that is federal law. 15 USC 1692G, validation of debts. Now, magic moment number two, anytime after they report to the credit bureau. Let's say you missed that 30-day window, no problem. There's a second opportunity. If that debt collector has reported something on your credit report, which they almost always do, you can dispute it at any time. And here's the trap they don't want you to know. If they continue to update your credit report after they receive your dispute, they must label the account that you're disputing as being in dispute. This is how you catch them lying to credit bureaus about your account status. 15 USC 1681I, dispute procedures. Now, magic moment number three, right before they sue you. Here's the nuclear option that debt collectors hate. Send a dispute letter before they file a lawsuit. Why? Because in a lot of cases, the debt collector claims that the borrower never objected to the debt. But if you've already sent a dispute letter, you have documented proof that they are lying. When you show the judge that green certified mail receipt proving that they received your dispute, that's when you go from defense to counterattack. That documented lie becomes a counterclaim. That counterclaim becomes your leverage. Now, there's a case, Rocky versus MedOne Solutions, in the Indiana Court of Appeals, where debt collector continued calling after receiving a cease and desist letter. The court ruled that the precise language plus certified mail equaled an FDCPA violation. The debt collector's senior attorney had misread the consumer's dispute letter. She stated that she was refusing to pay the debt. The attorney categorized it as a validation request instead of a cease and desist. The Indiana Court of Appeals overturned the lower court, and they held the debt collector liable, not because the letter was vague, but it had precise language, plus was sent certified mail. It was proof. So your words matter. Your words are proof. Follow for more credit tips.